This morning, a district court judge in New Hampshire issued a nationwide injunction against the Trump administration's executive order on birthright citizenship. Now, in light of the recent Supreme Court ruling in the Trump v. Casa case, you might be surprised to hear a nationwide injunction issuing from a district court against the entire executive branch. But this preliminary injunction may have been written directly in the playbook of Justice Gorsuch's concurrence in that case. I'm Brian. I make videos about civics and law. You can find copies of this injunction and several of the other documents leading up to it in the shared documents folder of my link tree. Okay, I'm going to explain to you what happened this morning and give you a little bit of legal context for how this came about. Now, I am still a little bit unsure of how the fallout from Casa is going to play out. And I think some of this is going to be trial and error, no pun intended. But this particular route actually was written in Gorsuch's concurrence, so let me talk about that for 1 second. Gorsuch mentioned a couple of things that he felt were holes in the final opinion that were not sealed and needed to be closed in order for this opinion to have any meaning. One of these was that so-called nationwide classes could be used to include essentially everybody in the country as members of a class in a class action. The decision in Casa does not stop district courts from enjoining the entire executive branch. They're still allowed to do that. They're just only allowed to do it for plaintiffs in that case. And so Gorsuch pointed out in his concurrence, well, if all they have to do is include everybody in the United States as plaintiffs in every case, then this case has no meaning. And while that's not exactly what happened here, it is sort of in that vein. This case appears to have been filed right after Casa, so this was clearly done in response to that case. Now the question here is whether children born on American soil receive birthright citizenship if their parents' immigration status is not up to date. And the reason I say up to date is that there are a lot of different reasons that immigration status can no longer be current. It doesn't necessarily mean that you crossed over the border without going through customs. It could just as easily mean that you were here on a visa for a long time and that visa expired. So the lawyers in this case have created a class of plaintiffs to include all children born to parents in that category. And the two things that the court did this morning were first, to certify that class, to say that the class that they have created is an acceptable class under Rule 23 of the Federal Rules of Civil Procedure. And then once the class was certified, then the court granted the preliminary injunction to protect all of the plaintiffs who happen to be every child born in the United States whose parents are not in current immigration status. Now, I do want to point out that you can't just put anybody you want into a class action. A class action has to be certified and it has to be in compliance with Rule 23 and a couple of unwritten rules. It's a very complicated field of law that makes up an entire chapter of this book. But I want to give you at least a little sense of the kind of questions that needed to be asked. So the first thing is there's something called joinder, which is where you can combine several different civil court cases into one. So one rule is that the class action is only appropriate where joinder is not appropriate. And a group this big is just too much for joinder. So that probably makes sense. And then, for example, the edges of the class need to be ascertainable. So for example, at one point, there was a famous case where the rules were way too specific and kind of bounced off each other in a weird way. I'm just going to read this because it's a little bit too much. The class was characterized as all people with Spanish surnames having Spanish, Mexican, or Indian ancestry who spoke Spanish as a primary or secondary language. So that was not an acceptable class. It's just too confusing, and it's too hard to figure out who is and is not in the class. However, when they narrowed it down to anyone with Mexican or Spanish surnames, that was acceptable. And then there are a lot of rules about making sure that the members of the group represent the actual group, and that whoever the lawyer is actually going to be able to represent everyone's needs in the group. And all of that stuff is actually addressed in the motion to certify this class. If you read it, you'll see that the lawyer says, hey, I've done this before, I have experience in this, and so I'm a good guy to do this. I am breezing through this concept really fast because it is complicated. But I wanted to at least give you a sense of the fact that classes don't just make themselves. You have to actually go through a process and demonstrate that this is a good class. In this case, the court listened to the plaintiff's arguments and decided that yes, this was a good class, they certified the class, and then they granted the preliminary injunction. However, this court in New Hampshire already stayed its own ruling for 7 days to allow this case to go into appeal because they know that the government's going to appeal this, and so they were like, we're not going to start this yet, we're going to give this a week, because there's no point in implementing this and then de-implementing it. We'll just automatically put a 7-day stay on this. So at the moment, they have certified the class, they have issued the preliminary injunction, but they have put a stay on their own order in order to allow this to go through the appeals process. I am absolutely certain that we will hear about this in the Circuit Court of Appeals and most likely the Supreme Court over the next couple of days.